Okay. All right, everyone. I think we're gonna go ahead and get started. Yeah, if everyone wants to take a seat, we can go ahead and get started. I've got just a few housekeeping things to kind of go through before the presentation, and pizza should be arriving at some point, I think around 11, although it's past 11, but soon enough. And I guess when it gets here, if y'all are hungry, you can just kind of go grab it, come back. I think you could eat in here. Yeah. Okay, so I know you all signed in outside, but we have our own sign-in sheet. HUD likes to just track how many people we train, and I wanted to address, there are two columns for race and ethnicity, and again, that is per HUD's guidance, and they just like to kind of know what types of populations we're reaching. So feel free to, you can list those if you want. If you don't feel comfortable, that's fine. But I just wanted to address that because I know it's kind of awkward sometimes and people have questions about it. And then I've got just a couple disclaimers based on feedback that we've had in the past. So the Denver Metro Fair Housing Center it's an advocacy and enforcement organization. So while we're not a neutral third party like the Civil Rights Division or HUD, because I know sometimes people have felt like this is not as neutral of a presentation as they would like, but I mean, we just follow the law, so that's kind of the angle that we're coming from, and obviously we help.
What's HUD?
Sorry, it's the Department of Housing and Urban Development. Yeah, federal department. So yeah, I just want to kind of let everyone know that before we get going, just so you know kind of just a little bit about the angle that we're coming from. And then also I kind of like this to be a more casual presentation, so if you have questions, feel free to just raise your hand or shout something out, and I can kind of answer as we go. And that being said, the nature of housing work, it's complicated. I'm sure a lot of people here know that. And each situation is very unique. And at these types of presentations, we often get a lot of hypothetical questions, like, if someone asks me for this kind of request, what should I say? Or, it just, questions that are hypothetical in nature, and sometimes they can be hard to give a definitive answer on. And sometimes it would be inappropriate for an organization like ours to give a very definitive answer on some of the questions that we get from housing providers and housing staff, because, well, I don't know. So I just want you to know that, a lot of times if a question is more difficult or it would require more explanation, I'll kind of touch base via email afterwards and answer it in that way. I do my best to answer everything in the presentation, but sometimes just for time's sake, it's easier to do that. So just also wanted to lay that out on the table. So I think with that, we'll go ahead and get started. There's also evaluations on your chairs, which we would love your feedback. It's very important to us. And then my business card, I'm Elizabeth Campbell, the outreach coordinator. So my business card is spread around, but I did run out, so some of you will have Rachel's business card. She is the intake specialist. And Renee is also here with us. She's our office manager. So with that, we'll go ahead and get started. Well, first I want to ask, how many of you have been to a fair housing training before? So some of you, good, awesome. Great, so yeah, basically today what we're going to do, it's just a 101 training, so we're going to talk about the Denver Metro Fair Housing Center and our mission and services. We'll give a brief history of the Fair Housing Act and kind of, the social climate that brought it about. We will go through the types of discriminatory housing practices and give you some examples. And then we'll go through the federally protected classes as well as the state protected classes in Colorado and kind of flesh out each one. And then we will touch on reasonable accommodations and reasonable modifications at the end, because usually there's a lot of questions surrounding disability rights in housing, so we'll kind of save that for the end. And then we have some like examples, but depending on what you all feel like doing, I mean, we can go through the examples or we can just kind of do questions and then that'll be it. So let us start. So DMFHC is a private nonprofit organization. We were established in 2012 with funding provided by HUD. And we also had some help from NAFA, the National Fair Housing Alliance. So that's kind of how we got started. And we're currently the only full-service fair housing enforcement agency in the state of Colorado. And I know, I mean, housing discrimination happens all over the place all the time. We would love to be statewide, but I mean, we have a pretty small staff right now, so the mission, the work that we do really is to eliminate housing discrimination and promote housing choice through education, advocacy, and enforcement of fair housing laws. So we'll kind of get into what that means in a little bit. And our service area currently is the 6 counties of the Denver metro area. So that's Adams, Arapahoe, Broomfield, Denver, Douglas, and Jefferson. So technically, we don't serve like the Aspen area, but we take calls from all around the state. We try to help people out as much as we can. We don't like to just turn people away. So if folks outside of our service area do reach out, we can try to do basic advocacy for them. Pretty much we can help them out up until the complaint process, and then they kind of have to be on their own through that, or if they have a private attorney, they can work with them. But we do try to help people all around the state because we know that there's a need. Our services are available in English and Spanish, and we also have access to a language line. So if there's another language out there, we can help those folks as well. And of course, our services are free of charge since we're a nonprofit. So let's get into some basics. So a very brief history of the Fair Housing Act kind of brings us all the way back to the Civil Rights Act of 1866, which basically established that, the recently freed slaves had the same rights as everyone else in the country. It struck down the black codes. It authorized the use of federal troops for enforcement, and it's still in effect today. Oftentimes when people file fair housing complaints, they'll cite that Civil Rights Act of 1866 as well. But as we all know, if you pass a law, just because a law is in existence doesn't mean that it's being enforced or that the public has the means to bring a complaint or do an investigation. So that Civil Rights Act was the basis of what we now know as the Fair Housing Act, but that act didn't quite get passed until 1968. And there were 4 original protected classes there. So those were race, color, religion, and national origin. In 1974, resulting from the feminist movement, gender was added as a federally protected class. And then in 1988, the Fair Housing Act amendments were passed. And that's what we always say, that those really gave the act teeth. So the amendments sort of fleshed out, what type of agency can do an investigation? How can an investigation actually be done? How can you gather evidence? What type of person has standing to bring a complaint? All of that good stuff. So the work that we do today was really made possible by those amendments in 1988. And it also added disability and familial status as protected classes then as well. So I will be going through these in more detail, but just a list for you right now of the 7 protected classes, and these are federal. So we've got race, color, religion, national origin, sex or gender. The way that it's written in the law, they're really referring to gender, but sex is actually in the law. Familial status, So that's the presence of children under 18 in the home and disability. So those are federally protected. Statewide, we've got 4 additional protected classes. Other states have a lot more than 4, but I think we're doing all right. We've got ancestry, creed, marital status, and sexual orientation. So a person could bring a complaint based on their sexual orientation, at the state level, but like HUD wouldn't touch it. You couldn't touch it at the federal level because that's not protected. So a bit about the complaint process, and this is kind of just like a quick and dirty of what we do. So someone calls our office and they're like, I think I've been discriminated against. I'm not sure, but it might be because of my national origin. So we will ask them, a series of questions to try to narrow down, is this in fact discrimination? Is it a different issue? Is it a landlord-tenant issue? So that's more like, that's not discriminatory in nature. It might be violating landlord-tenant laws in the state, but the Fair Housing Act is pretty limited in scope. So if we decide that they don't have a fair housing issue, we refer them to an agency that hopefully can help them. If they really want to, if they feel very strongly that it's discriminatory, they can always file a complaint on their own, just as their own self-advocate through the administrative complaint process. So that is an alternative to a lawsuit. It's free. So they would file a complaint with HUD or the Colorado Civil Rights Division. And eventually an investigation would happen, a determination would be made as to whether there's probable cause that discrimination occurred or did not occur. And then there's usually, there's a conciliation. You hammer out the terms of a settlement. Sometimes there's settlement funds. Sometimes it's more injunctive relief, like a housing provider might have to attend a fair housing training or promote, put fair housing posters up in their office or affirmatively market to specific groups of people that maybe they were discriminating against.
Do you guys do the investigation yourselves?
So we do. It's a little, so we aren't an agency that do we do the investigation ourselves? Yes, we have investigative tactics that we can do. So fair housing testing is one of those. I'm sure some people are familiar with that. It's a bit like secret shopping. So we have a trained pool of testers that goes out to a subject property and they pose as renters. And that's how we get evidence, as to whether discrimination really did occur. The Supreme Court says that it's okay for us to do that. So I know it seems a bit cloak and dagger, but if a housing provider is not discriminating, we're not going to find evidence of it, and it would be fine. So yes, we do investigative things, and so then what happens from there is once we have done our investigation, we'll kind of package it up, write a complaint, and then we submit it to HUD. So we're like the advocate for the complainant throughout this process. And then they have to go through HUD's intake, obviously with our support and our help. And then depending on if the evidence that we've submitted is sufficient, sometimes they'll just make a determination based off of that. But if it's not, they'll do their own investigation as well. So I hope that answers. Yeah. Question?
So since we're out of your service area, if someone does call you with a complaint, do you take in the complaint or do you refer them to the Division of Civil Rights?
Right.
Or do you bring the complaint to the division for them?
Yes. So can we take complaints outside of our service area was the question. It kind of depends. If it's a really large systemic complaint, like say it's a housing provider that has tons of properties all over the state, we can sometimes justify that within our funding to do some investigative work outside of our service area. Unfortunately, we can't always accommodate that kind of thing if it's a smaller issue, like a mom and pop. I mean, no one's discrimination is a small issue to them, and certainly not to us, but we are limited in our scope. So in that case, yeah, we would refer them to the Civil Rights Division. We would even kind of help them understand what does the complaint process look like, because it's a bureaucratic mess. I mean, it's not a mess, but it's just a very bureaucratic experience. And honestly, like, before I started this work, I couldn't have navigated through that. It's pretty confusing. And if you don't have an advocate, you know, you might not get a determination in your favor, even if the discrimination did occur. So yeah, I mean, we try to help people as much as we can until it's to the point of, like, you need to file a complaint, and we say, here's what you need to do. Maybe here's some resources in your area, here's some attorneys, that kind of thing. So the other bit about the complaint process, a mediation and conciliation can occur at any time. So if a housing provider gets a complaint filed against them, you know, it doesn't have to go all the way to the end where it's determined that, like, yes, they discriminated. If they know that they did it, or they just want to resolve it, at any time they can say, hey, let's work this out. You know, let's sit down, have a mediation, hammer out some settlement plans, and it can get resolved, like, before it actually goes all the way through the end. So that's an option that housing providers should know about. You know, you're not, like, locked into this trajectory necessarily. Question?
What would a settlement look like?
Well, each case is unique. Sometimes, like, we have gotten settlement funds for people. A really large complex in Denver that we filed a complaint against, they actually had to establish a victims fund. Sometimes, you know, the complainant gets some settlement, we get settlement money, but we usually distribute that back out into the community. It's not, like, just in our pockets. So, you know, that's kind of like the big scary terms of settlement, but there's also just, like, attending a fair housing class, or, like, attending a fair housing class every 6 months for 2 years, or, you know, like I said, we had one where the guy was discriminating against families with children, and he had to, like, affirmatively market to families with children. So it can kind of, it's kind of up to the complainant. We've had people say, I just want an apology. Like, I don't want money, I just want an apology letter, which landlords really don't want to apologize to people. It's funny, they'll sometimes say that they regret, like, they're willing to write a letter of regret, but not a letter of apology. So, you know, people can get creative, but yeah, so that's kind of what settlement can look like.
I have a question. Have you ever had any communities that have worked to help people get, like, accessibility into, you know, like, if they're in an accident and they're suddenly in a wheelchair, but the complex they live in doesn't have any wheelchair accessibility? Mm-hmm. Have there been any communities where they've helped people find ways to get accessibility to their units?
Yeah, so the question was, say someone suddenly becomes disabled, and the apartment complex that they live in isn't built to accommodate, like, you know, a wheelchair or something. Were you asking, are there specific communities that do that, or, like, do we have ways of helping people achieve that? Both?
Yeah.
I mean, there are definitely assisted living facilities. So, I mean, those are always an option. I don't have, like, a list off the top of my head. Usually at that juncture, we would kind of refer them to maybe, like, the Colorado Cross Disability Coalition, because they might have a better idea of which complexes, you know, are specifically assisted living. But yes, we can also help them request, so that's what's called a reasonable modification, I guess, if you're asking about, like, a ramp, you know, or, like, grab bars. That is something that is covered under the Fair Housing Act. So I will touch on that a little bit later in the presentation in lots of detail.
Because I live in a complex where we actually designed the units so they could be
Yeah.
modified. If
Yeah.
somebody, you know, it's 21 units, and it's
Mm-hmm.
one of those things where I wondered if there are any other places where, you know, you can very easily put in a stair lift or something.
Oh yeah, like there are in a lot of like the new buildings in Denver, they'll have what they call ADA units. So they're like they're accessible or they're easily modifiable.
But the problem is getting the city council or getting the city government to approve the construction when it's already been there for 25 years, kind of a thing.
Yes, yes, and I'll touch on that as well. There is a set of design and construction rules under the Fair Housing Act that kind of addresses that. And I can, like, if you want, I could send you, like, there's a whole booklet about it. So, yeah, we can touch base after if you want, but I'll also talk about it in a few. Yeah. Any questions? Okay. So these next two slides are a little outdated. We need to update our numbers, but they're basically just meant to show the national trends and then the state trends in Colorado. So nationally, and it's been this way for a very long time, disability is far and away the most common fair housing complaint that's filed, disability-related complaints, followed by race and then national origin. So there's probably many reasons for that. I think disability discrimination is often more blatant. You know, it's no, you can't have a service animal, or no, I'm not going to build that ramp, or something like that. Whereas maybe like racial discrimination, it's really hard to prove. It's very insidious. People don't just come out right and say the kinds of things that they did in 1968. So I think that might be why it's so skewed like that. And then you'll see Colorado's pretty much mimic exactly the national trends. Retaliation is listed. So basically retaliation is if someone is engaging in a protected activity, like asserting their fair housing rights, even if the complaint is like frivolous, it's still their right to exercise those rights. So if a housing provider retaliates against them because they filed a complaint or because they requested a reasonable accommodation, if they say, you know, you filed a complaint against me, I'm going to evict you, or no, you can't have your service dog, and you know what, you're just too much trouble, I don't want to deal with you, evicting you. That would be retaliation. So that's also protected. So we will get into the specific discriminatory housing practices that are actually listed in the law. I'll kind of talk through those. So the first one is refusal to sell or rent. That's pretty obvious. It's just like refusing to sell or rent to someone, turning them away, saying, I'm not going to take your application, that kind of thing. And again, it's important to remember that all of these practices are, you know, it's if you refuse to sell or rent to someone based on their protected class status. It's not just like, you know, your ex-boyfriend, I don't know, you don't like him, don't want to rent to him. That's, yeah, right. And they often are. So that's the first one. Terms and conditions is also in the Fair Housing Act. So if one set of people is being told something different than another, that's a bit vague. Say a housing provider is only doing background checks on certain people and not on other people. Or if, say, a family with children comes in and they say, okay, your security deposit is going to be $300 more than the couple with no children because kids cause damage to the unit. That would be differing terms and conditions. So, I mean, the important point there is just to make sure you're telling, I mean, everyone should be getting the same spiel in the office. Steering is artificially limiting someone's housing choice. So, you know, steering a Muslim applicant into a neighborhood because you're like, oh, there's a mosque there, that'll be great for you. That even kind of sounds like it might be, like a housing provider might genuinely think that's like a nice thing for them to do, but intent doesn't really matter. You're still limiting their housing choice. Or like putting a family with children in the back garden level because of noise. You know, you don't want them on the second floor. We've also seen housing providers not wanting to rent to families with children like on the second or third floor because there's a balcony and they think it's like a safety concern. And again, it very well could be, but it is up to that family to decide, you know, am I comfortable living here? Am I not? So yeah, steering. Lying about availability, that one's also pretty self-explanatory. If someone sees a Craigslist ad, they come into the office, they say, hey, or they call first and they say, hey, is that available? Landlord says yes. They show up to the office, the landlord gets a look at them and they say, actually, no, that's been rented, when it actually hasn't. That's also prohibited. Advertising, that can be as blatant as just like no kids. But it's also important to note that if you've got promotional materials for your complex, it's important to show diverse people on your promotional materials, because, you know, if someone in a protected class might be discouraged from applying to a place if they see like just white people on the cover, or sometimes we'll see places that say like active community, and you know that might discourage someone in a wheelchair. So it's important just to kind of, you know, have all your materials be inclusive is the takeaway. Threats, intimidation, and coercion. You know, well, we've heard of sexual harassment, landlords sexually harassing tenants. That can be men or women, obviously. Or gender non-binary folks as well. That also covers like neighbor-on-neighbor harassment, which is, it's a little more difficult, but if a resident makes a housing provider aware that they're being harassed and it's based on their protected class status, so like say someone has an emotional, no, I won't use that example. Say someone has like a caregiver who comes in and helps them with their daily life activities, and the caregiver is entering, you know, has a key to the laundry facility, and another resident is like, hey, I don't like that person has a key to the laundry facility, they don't live here. And then they start harassing that other resident who has the caretaker. You know, that's an example of sort of threats and intimidation. And if that resident makes the housing provider aware that this is going on, it's important that the housing provider does take steps to address that. The last one, making housing otherwise unavailable. That is intentionally vague because discrimination changes and morphs every single day. It doesn't always fit into like tidy little boxes. So that one is there, that last point is there to really cover all the new and fun types of discrimination that we encounter all the time. So yeah, any questions on these practices? No questions? Question?
Are there any exclusions like Mrs. Murphy rule or anything like that? Do you want to go over that?
Yes, so he was asking about exemptions to the Fair Housing Act, and there are, and we will get into them, I think fairly soon here. Steering, I think I kind of already covered most of this for you all, but question?
So age is not a protected class. Like if someone were a senior citizen, it's only familial status, as in if you have kids.
Right. Yes, age is not a protected class. Familial status also does cover like pregnant women. If a couple or a family or a person is planning to adopt, they're covered there. It covers like non-traditional families. If, you know, you don't have to be like a legal guardian to be covered by familial status. If you're just like, God forbid something happened to my sister and I take in like her child, but nothing is like legally bound, I would still be protected there. So, and the child as well, obviously. So yes, steering. I think I kind of covered this for y'all. We'll move on. So what units are covered? The Fair Housing Act covers most housing. It's like really difficult to be exempt, but there are exemptions. So owner-occupied buildings with no more than 4 units. That's the Mrs. Murphy exemption. And that is essentially like the reason it's Mrs. Murphy. It's like little old Mrs. Murphy. She's a widow. She lives in a big rambling mansion, and she has converted that space into multiple like standalone units. But it's fewer than 4 because she lives in the 4th. So she's renting out 3. She is allowed to be a bit more discerning. I don't want to say discriminatory, but I mean, that's what it is. Because, you know, it's a bit more of an intimate situation. There might be shared living space, maybe not, but still they're like living in the same house as her. And she is just an example. You know, it's anyone who owns the 4 or fewer. So that is an exemption. Essentially, she could, at the federal level, she could say, I don't want to rent, you know, I only want to rent to women. I only feel comfortable renting to women. And she could do that. However, there are some caveats here. If Mrs. Murphy were to advertise in a discriminatory manner, she put a post on Craigslist or she put a sign in her yard that said like women only, she would lose her exemption. So that's something to know. The other bit is that, and this is kind of confusing, so if you have questions, like let me know. It's kind of confusing even for me to explain sometimes, but under Colorado law, basically the state of Colorado does not honor the Mrs. Murphy exemption except when it comes to familial status. So in Colorado, Mrs. Murphy could say, I don't want to rent to families with children, to herself, obviously, not to the world. And that's okay, but she couldn't say, I want to limit my tenants to like men or women or, I don't know, certain races, that kind of thing. And that's kind of confusing because, you know, federal law trumps state law. So if someone really wants to push that, they could take it to the federal level, where Mrs. Murphy would still be exempt. But does anyone have questions about that right now? Yes.
I'm not sure if you'll get to this part, but it makes me think of, you know, if you're not an APCHA unit, but if you're free market and you're renting out your ADU, whatever it is, you're not renting through a landlord, you are handling it yourself. Are you allowed to run or like say require like a credit check? Or specific, like, I've had some of my employees I work with, saying, it's just like a single unit in somebody's house, but they're asking for like bank account information and all this stuff. Again, not an APCHA qualified unit, like totally out of the APCHA system.
Yeah.
And legally, can they require
a credit check? So the question was, can like a private landlord, maybe with just one unit, right?
Yeah.
Require a credit check or other like financial information? Yes, because that. Well, if they're applying it equally, if they're saying to, I don't know, the single woman, like I'm gonna need to do a credit check or whatever, but not to like the couple. Basically, as long as the reasoning behind that is neutral and it's just to determine, is this person going to be able to pay the rent? Are they going to be able to, be a good tenant? Do they have a good rental history? Do they make enough money to live here? Yes. But if it's being applied selectively, that's where the problem comes in.
Providing like their bank account number, like they shouldn't be doing that.
That seems weird.
Right.
Yeah.
Right.
That seems weird. I don't know that that's a violation of the Fair Housing Act, again, unless it's being applied like selectively to certain people. But that might be like a landlord-tenant. Like, I don't know that landlords can legally do that in Colorado. So you could try calling like Colorado Housing Connects. You familiar with them? They're like they have a hotline number for landlord-tenant issues. So they're based in Denver, but I mean, anyone can call. So they're the go-to for questions like that. Wait, you had a question, right? Did someone over here? Okay.
So similar to the credit check question, if the person doesn't have a credit history because they're just from another country, can the landlord deny renting to them for lack of credit history?
No. Okay. The question was, can a landlord, if someone doesn't have a credit history because they are from another country, they're an immigrant, can a landlord...
Immigrant, but we have obviously a million work visas.
Oh, for sure. Yeah. Work visas. That's a good question. I might want to dig into that before I try to give you a definitive answer, if you want to catch that, Rachel. I know that if you have an I-10 card, you can build credit with that. So, and I guess again, it's who is that being applied to, right? Are you you're a British, you have a British work visa, you're fine, I don't need to check your credit. But say the Salvadoran person, they need the credit check. That could be potentially national origin discrimination. But if you're applying it just to everybody and treating everybody that way, even obviously citizens and stuff, everyone has to get the credit check. That may not be a problem, but I definitely want to confirm that for you. Question?
So we manage quite a few properties, and some are APCHA, some are not. We have a lot of individual owners, and the individual owners have their own guidelines for what they want in their unit, as far as I want 3 references, I want a background check, I want their friend's name, their what they require is different from the next owner. So as a company, we accommodate all of these different owners, but should we be consistent across the board as a company, or can we say, well, this owner versus this owner wants something different, so we're really not discriminating, we're accommodating our
Right. As long as what the owners want isn't discriminatory, then you should be fine. Yeah. All right. So a couple more exemptions. There is a housing for older persons exemption. So that permits, the housing complex to exclude families with children under the age of 18. So in order to qualify for that exemption, it's not one day you're a private landlord and you say, I don't want to rent to families with children. This is now housing for older persons. That's not really how it works. You have to, if you are a HUD housing or something, obviously the funding that you're going to get from the federal government will dictate this is senior housing or something like that. So that's one way to qualify. Another way is if, I think it's 80% of the tenants that live there are 55 years of age or older. And that doesn't have to be all the tenants, I should correct myself. That's just people, if there's one person in the unit who's 55 or older, there could be others who aren't. But that depends on the housing complex. If it is housing for older persons, it's reflected in their policies. That's really at their discretion. If they want to say there are absolutely no people under the age of 18 here, that's fine. If they want to say, as long as 80% of the units are occupied by a person in that age range, that's also fine. But again, all of that has to be reflected in the policies, especially if, it's a federal program that's, in the funding. So that's how you get the housing for older persons exemption. Any questions?
So not in relation to the exemption, but in relation to elderly people in housing? What obligation as a landlord do we have to, number one, if there's an elderly person who can't care for themselves anymore, or is a danger to themselves and other people in the apartment complex?
Yeah. Well, if they can't care for themselves anymore, that one's tough. I mean, we have gotten a few calls about that, and I mean, ultimately, that it's still their housing choice, right? Like, you don't want to be limiting people's housing choice. I would hope that maybe their family would intervene or something, but again, age isn't protected, so I don't know. I wouldn't like. Are you talking about like eviction? Yeah. Oh, just like non-renewal.
Or contacting other sources to help them make a decision.
Yeah. I mean, hopefully that approach would be the one that's taken. Maybe trying to work with the tenant. I know that, you know, older folks can sometimes, depending on what they're going through, can be resistant to that kind of stuff. But yeah, again, age isn't protected. So if
I guess that could apply to any age, but if we have those situations.
Yeah, and if someone is like a direct threat to other people, that is, even if it's disability related, you know, if they pose a threat, and it has to be, with the direct threat thing, it has to be, you have to do an individualized assessment and say, is there direct evidence that this person has like threatened someone or actually hurt someone? It can't be based on like fear or speculation about certain disabilities and what people might do, or like what, you know, the common consensus is about that particular maybe mental illness or something. There has to be that like direct evidence that you can say like this person is actually a threat to other people. As far as a threat to themselves, I don't know. I don't know the answer to that, because it's kind of hard to say. You know, on the one hand, it's like, why does my housing provider need to know? Why would they even know, like, if I'm a threat to myself? You know what I mean? It's like, why are they in my life at that level? But I also understand. I mean, of course, you want to look out for the health of your tenants. You don't want something like really tragic to happen on your property. So I mean, I don't know if that answered your question fully, but
Not fully.
yeah, I can, catch me after. Anything else before we move on? Okay. So what transactions are covered? Pretty much every housing-related transaction that you can think of. Rental, lending, sales, homeowners insurance, zoning. So even like a municipality, if they have a discriminatory zoning law, like the city of Aspen could be a respondent in a fair housing complaint. And I think that kind of goes back to like the history of redlining and all of that. So, yep, anything that you can think of pretty much is covered. So who has to comply? Again, anyone engaging in that housing-related transaction. So insurance agents, lenders, leasing agents, property managers, owners, you know, and that can get kind of tricky because sometimes, like, say you own a complex, you employ like a third-party management company and they have their employees, one of their employees is discriminating. You might not know, but that's still kind of your job to know and to make sure that the company that you're hiring is, you know, taking steps to not discriminate. So it's just important to know that like ignorance isn't really an out. Okay, so let's get into the protected classes. I guess before that, do we have any questions? No? Okay, so race and color. Very similar. People often wonder like why. Sometimes I wonder why, but I know the answer. Race discrimination involves treating someone unfavorably because of their race or characteristics associated with that race. So that could be like, I think we have up here, hair texture, skin color, facial features. Skin color ties in with color. So that color discrimination is just treating someone unfavorably because of the color of their complexion. Obviously, folks who are the same race can still discriminate against each other. Kind of goes into like colorism and all of that. So like, I think that's why color is a protected class as well. Religion. So housing providers can't have policies that restrict the free exercise or practice of one's religion. And we kind of get into disparate impact theory here, where a policy might not be discriminatory on its face, but when it's in practice, it actually does disproportionately affect certain groups. And, you know, if there is a rule or policy that hinders someone's religious practice, there just needs to be a neutral reason as to why that policy is necessary. You know, how is that helping the housing provider administratively? You know, how, yeah.
Can you give us an example of what,
Yes. I actually have some examples on the next slide. I'm trying to think of like a specific example for that. Renee or Rachel, do you have any ideas?
Well, if you find out someone is an atheist and you have a religion and you just think that's not someone you want renting from you, when really it shouldn't come into play. Or if you try to have someone live, well, the example you used earlier about living near a mosque, steering someone that way, that's...
Right. I guess it's like whatever the policy is, how does it help, you know, how does it help the housing provider achieve their goal of like providing housing and renting to folks that qualify and that kind of thing?
well, and I'm more so thinking, like, have you guys come across any rules that have hindered somebody's being able to practice religion? So have you, that's more so, I know
Yeah.
you're definitely like, you know, why not to discriminate against different religions, but if you run into, you know, you can't, a noise violation past 9 p.m. and you find out that somebody practices a religion that does
Yeah.
noise. I don't know. That's
Right.
kind of what I'm thinking of. Like,
Yeah.
you run into policies that do kind of end up overlapping into that.
Yeah, so like we had one where burning like incense was part of someone's religion, and there was like a no candles or burning things policy.
What was
So
the
what
outcome
trumps
of
that?
that?
Yeah. I mean, we didn't file a complaint on it because we just wrote a letter to the housing authority that in question, and we were like, hey, this, you know, is potentially limiting this guy's ability to practice his religion. You know, he's not just like burning stuff when he's not around, and they let it go. So, I mean, if a housing provider wanted to say like, actually, I think that's a threat, you know, that's a potential safety hazard, they could try to make that argument, and the person the complainant could file a complaint if they want, and ultimately the courts would decide. Yeah.
Could you go after security deposit if it went in and smelled like incense and just say, hey, listen, you're in this apartment, you owe us money for it, because they were doing that.
Yeah, I mean, if it was ruined, you know, if it's more than just like normal wear and tear, certainly, yeah. Or if like, say they were burning candles and like the walls were totally like ruined with smoke and yeah. Questions? Obviously specifying a preference to a particular religion, that's easy. A housing, like a shelter or a state institution that gets federal funding, if they serve meals, they have to be able to accommodate like religious dietary restrictions as well. They also can't require that someone participate in like a religious ritual or ceremony or something, or activity as a condition of them like being accepted into that shelter. You know, I know a lot of shelters have like prayer, and that's fine, but you know, it's like if someone doesn't want to participate in that, they can't like force them to or say you can't be in this shelter. Yes.
What if it was an emergency shelter? Do they have, you know, like the recent wildfires and you said the school is a shelter, do they have to be cognizant of that too?
Of fair housing. Yeah, so with shelters, it kind of gets into what let me restate the question for everyone. The question was, does maybe a temporary emergency shelter, like say for wildfires going on, if it's a school and it's turned into a shelter, do they have to comply with fair housing laws? The answer is it depends. It gets into what constitutes it as a dwelling. Generally, if someone is there for like a week or more, there's no like actual rule as to like how long a person has to be in a place, but we usually say like a week to 10 days. If they keep their belongings there full time, if they get mail there, which they might not. Yeah, but if it's like an overnight thing, I'm not sure that that would necessarily be considered a dwelling. Yeah. There are religious exemptions. I don't know if that was on the other slide and I just skipped it, but if a housing complex is limited to, if it's religious in nature and it's limited to members only of that religion, that's an exemption. But again, it's the same deal as the others. You can't just like decide that on the fly. Although, I don't know, maybe in Colorado you can with some recent Supreme Court decisions. But generally, it has to be reflected in your policies. You can't just decide that you don't want to rent or that, your apartment complex is just for a certain group. So now we'll get into familial status. So this, again, covers families with children under 18, pregnant women, child living with a legal guardian, persons on planning having a family, traditional and non-traditional families. So, a bit about familial status, because we get a lot of calls about this, and we get a lot of questions from housing providers. Rules about behavior as applied to children. Generally, if there's going to be a rule, it should just apply to everybody. If you want to have quiet hours after 9, that's great. That's fine. I mean, adults are perfectly capable of being extremely loud. So it should just apply to everybody. It shouldn't say like no children making noise after 9 or no children running by the pool. I think that's what I have. Yeah. Making loud noises in business centers. The non-discriminatory rule there would just be all residents must be refraining from making these loud noises in the business center. That seems really easy to me, but this comes up a lot. So, just have the rule apply to everyone. No big deal.
What about children must be supervised?
Yes. What about children must be supervised? Safety concerns. So rules about play or pool use, restricted access to certain areas. If it's a safety concern, if it's like a 2-year-old alone in the pool, I think that is okay. You might want to consult with a lawyer just to be sure about how to maybe phrase that correctly. But it can't be no minors, because it's a 17-year-old can be in the pool. That's should be fine if they're not causing a ruckus. And again, if they are causing a ruckus, it could just be no one can be causing a ruckus in the pool, rather than just the minors. And you also might want to visit the local, maybe county laws or regulations or municipal codes for safety, or maybe how do public pools handle it. I know that those are public accommodations, so it's different from housing, but it might be a good indicator of that. Another bit kind of going off of that, if an unsafe condition does exist on the property, consider just making it safe. I mean, obviously with a pool, it's a little different because it's you can't make a pool safe for a 2-year-old, but if it's something else, rather than limiting where children can go, just consider making that space not a problem for children to go. And again, personal items, we've seen a lot where it's oh, there was a ball in the parking lot, or ball hit my car. And you can just say personal items must be kept inside rather than children's items. Cool. Questions? Okay. Occupancy limits is another big one. Generally, the rule of thumb, kind of federally, is 2 persons per bedroom, 1 in the living room. So that's livable space. That doesn't count like the kitchen and the bathroom. Although I think the kitchen is livable space because you cook, but yeah, 2 in the bedroom, 1 in the living room. That's from the Keating memo. That's from HUD. So that's kind of like a vague rule of thumb, but every county and city has their own rules as well. So definitely visit, like, what are the Pitkin County, like, codes on occupancy limits. And again, be sure to consider that maybe those codes are discriminatory. But, you know, consider like the size of the bedrooms and the overall unit. Age of occupants, that's a little weird because it's like, then you're getting into familial status territory. But, you know, how's the unit configured? Is it like, I don't know, 300 square feet and it's a 1-bedroom? I don't know of any 1-bedrooms that are that big. And it's like 3 Broncos players want to live there. It's like, well, how's that going to work? But, you know, if it's a massive, like, 1,500 square foot 1-bedroom and it's a husband and his pregnant wife, you know, they shouldn't be denied from living there. But it does happen. Yes?
So if I have a landlord that doesn't think a son and a daughter should share a room, would that be discriminatory?
Yeah. I mean, because there's gender and sex discrimination. Although, I guess I don't know. I might have to kind of like work through that in my mind to kind of see the fair housing angle. But, I mean, generally, yeah, you know, it's like that's that family's right to say, like, I want my kids to share a room. I don't know, you know, go on.
What about just as far as occupancy, like if you had a 3-bedroom and you had 3 couples, like 6 people living in this 3-bedroom, could you be like, no, that's way too many people living in a 3-bedroom?
3-bedroom, 3 couples.
Yeah.
That is a lot, but I mean, again with that.
You just set an overall cap on saying this is a 3-bedroom, we can have 4 people living here total?
I wouldn't recommend that because, you know, if say it were a family with 3 kids, 2 parents and 3 kids, you know, so it's, we generally like steer people away from making like specific rules like that. It's more like, look at the age of the occupants. How is the unit configured? Yeah, it seems like a lot of people, but, you know, could it fit 6 adults? Yeah. But kind of where the occupancy limits become discriminatory is with familial status, mostly. So if it's just like, you know, 6 college kids, I don't know that that would be a violation of the Fair Housing Act. But it could be like marital status. That's something to consider. Like if it's like, well, I don't want an unmarried couple like living in sharing a bedroom, that could be discriminatory.
Can municipalities make rules about how many unrelated people can live in a home?
So the question was, can municipalities make rules about how many unrelated people can live in a home? That one, I actually have an answer. I'm going to check my notes because it's just a lot of info. So a household or family is defined as any number of persons related by blood, marriage, or adoption, plus A, domestic servants employed for service on the premises, so like a caretaker, maybe, or like a maid if you want, I guess. Up to 4 children under the age of 18 who may not be related to any or all of the other residents. But who are under the care and supervision of the adult family head. Any combination of Yeah, this is confusing. It might be better if I just like email this to you, because it's like any combination of A or B, not to exceed 4 individuals. A group of not more than 4 unrelated or related persons living together as a single housekeeping unit.
And is this what you're reading from Fair Housing?
This is my slide, like the notes on my slide. So there is a source for this. I could share it with you. I know it's kind of like doesn't make a lot of sense like reading it out loud. But I'll email it to you if you want that information.
I've just heard that throughout the valley, there's different rules in different towns about how many unrelated people can live together, and that sort of drives where multifamily renters are, and I don't know if that's true or not.
I mean, again, it could be, that brings us back to marital status. Like, you know, if I'm living with my girlfriend, my friend, who's a girl, a woman. Right. Well, but that's more, that gets into other sexual orientation and stuff. But, like, my pal, if I'm living with her, and it's like, well, you're unrelated, I could probably say, hey, just because I'm not married to this, you know, that's marital status discrimination. So, yeah.
Thanks.
Yeah. Questions? Okay. Okay, so state and local laws. For example, many of them are based on like square footage. So in Denver, and I'm sorry I don't have like what Pitkin County is or Aspen, that was an oversight. In Denver, I know that at least, so it's 150 square feet of livable space for the first occupant, so myself. And then for each additional occupant, like my roommate, my husband, my kid, whatever, there needs to be an additional 100 square feet. So, I mean, that's like not even that limiting, because technically I could live with 2 other people in a 400 square foot apartment, which like nobody wants that. But you know, that in Denver, that would be legal. We had a complaint specifically that was, it was a pregnant woman and her husband, and they were denied a 750 square foot bedroom because once the landlord found out that she was pregnant, he was like, oh, nope, no more than 3 people, or no more than 2 people. Yeah, so we, you know, he had to pay us a little bit of money as well as them. So, you know, sometimes the state and local laws will be even less restricting than like that 2 per bedroom, 1 in the living room thing, like, because they're so, like the Denver one is. So it's just important to kind of like do the research there, see what's going on in your community. Basically, right, overly restrictive occupancy standards that unreasonably limit the number of people can be considered discriminatory. That's just like the baseline. Are there any questions about occupancy? Okay. National origin. There was a question.
No, I was just going to ask, are children required to be on a lease?
Are children required to be on the lease? I mean, if they're not paying rent, maybe. I think that's a landlord-tenant question, but I would think if they're not like paying rent, they might, it's like, well, they're, you know what I mean? Like it's, but.
I don't think so.
But otherwise, you don't know how many people are in.
That's true. Yeah, I mean, you might want to have them on there, but obviously.
For example, I had 2 people in my rental place down in Denver, and he had his 17-year-old son move back with him.
Yeah.
And all of a sudden, I'm like, you have your son living with you? I mean, it's cool.
Oh, yeah.
Just like, you know, you gotta let me know that.
Oh, yeah, I think it's reasonable. Yes, if someone is going to have someone move in, whether or not they're like a little baby or 17.
I know if they're dependent or not.
That.
So in other words, adult-age children, you can require them to be on the lease.
Yeah, like if I'm moving back in with mom and dad at age 29, well, they own their home, but if they didn't, yeah, I would want to, you know, yes, sorry. Okay, does that, are we good? Okay, cool. Anything else? I feel like I get like, I look at one area.
Can you set up, I've definitely seen, you can have visitors but not for more than whatever days, I mean, is that legal as long as it's part of the lease terms, or is there a piece of that related to this too?
That's legal. I mean, because if they've got someone staying with them, it's like, well, you're for a long time, months, weeks. It's like, well, is this person living here?
Yeah.
You have a right to know. You're the landlord. Yeah. Question?
Yeah, on the one where providers the identification, can you just say, I need 2 forms of identification, but not say what they are?
Oh, yeah. I totally got lost on this slide because we were still talking about occupancy. No, that's fine. The question was 2 forms of identification.
Yeah, I mean, just say 2 forms of identification, because this says you can't, require certain forms from some people.
Right.
But as long as they have 2 forms, you're still covered, pretty much.
Yeah, yeah, if it's common practice, if you ask that of everyone, you ask that of, right, everyone. Yeah. But yeah, things like an I-10, like that could count. Green cards. If you ask everyone for their green card or everyone for their citizenship status, I suppose, that's fine, but
not everybody has a green card.
right, yeah, I mean, not everyone, like, obviously,
Passport, so.
right, and not everyone has a passport, so, if they can give you a form of ID that establishes that they're, like, a person in the world, why not? Well, right, that, and that's kind of what this slide is about.
Would that be discrimination?
If you deny everybody that has a green card, it would. So that type of thing, you could ask for the IDs, but if it turns out that you're denying all of the people that have a green card, that would be discrimination.
Well, yeah, because
What about people that don't have a green card or don't have a passport, an American passport? Can they provide their
country of origin?
Yeah. You can ask, you can ask for the IDs,
ID? Yeah.
but not as a way to discriminate.
Right.
Yeah, that's
An
where
ID,
the,
whatever.
Yeah, and it's like, again, back to that example, it's like, are you asking the Hispanic immigrant for their green card and not, like, the Brit? That's where the discrimination comes in.
Yeah.
yeah.
Any other questions? So yeah, national origin, sorry, we're kind of jumping around, but it's, discriminating against someone based on their birthplace, ancestry, culture, or language. They're born outside of the U.S. That's their national origin. So violations include both preferential and adverse treatment. So if you're like, say, maybe you're not like actively turning away certain types of immigrants, but you're like showing preferential treatment to others. Yeah. So fair housing and sex and gender. So again, this came about thanks to the feminist movement, the second wave. So yeah, this is a little wonky, but sexual orientation is not protected federally, and this comes into play often with sexual orientation. If a housing provider is like, you aren't acting like a man and how a man should act. So I don't like you, I don't want to rent to you, I don't like people like you. If it's based on a gender stereotype of how someone should be in that person's opinion, that would be sex discrimination. And again, obviously excluding someone from like a HUD-funded property because of their gender identity or non-conformance to gender stereotypes. And that one's kind of hot right now because, there's, say you are a trans woman and you're going to a women's shelter. There's a lot of pushback. There has been a lot of pushback about like, I don't feel comfortable, I don't want this person to be in this shelter because, well, they're not really a woman or whatever, I don't know. Yeah, so, you know, if someone states what their gender identity is, that's how they should be treated. You know, however you identify, you get to access those kinds of federally funded programs, bottom line.
So a woman's shelter would not be a discriminatory thing.
Right. Well, actually, we had this question last time.
Housing.
Yeah, we had this question last time. Technically, oop.
Uh-oh.
I mean, I'm still on. I'm still alive.
I did that.
Oh. Technically, like, I think, yeah. Like, technically, women's shelters are, like, under the law, but no one's gonna bring that complaint. Like, I think we've actually talked with the National Fair Housing Alliance about this, and they're like, are you gonna, not because we wanted to, but they're like, no one's gonna be that fair housing org who's, like, going after women's shelters. Like, nobody,
Right.
I don't think even HUD wants that. So, like, technically, it is illegal as the law is written out, but, like, they serve their purpose, and I know it's kind of weird. It's kind of weird. Like, if a man really wanted to be like, that's the hill he wants to die on, like, I want to be in this women's shelter and I'm going to file a fair housing complaint because that's discriminatory, he could do that.
There's some of those too.
Oh, I know.
It's still on.
It's still, oh,
Yeah, it's still being recorded and everything. It's just that one off.
okay.
The live feed is still
Oh,
on.
but
That's
like,
what I'm saying.
they can't see any of it though.
I can see you.
Well, I know they can see me.
Oh, okay. Yeah, I just want to know the screen was off, but
Yeah.
they can still see you.
I know that.
Okay.
Did I say something out of line? Yeah.
No.
Okay. You're like, they can see. Questions?
I know there's like limitations on national orientation. What about like, you know, within the state? Like, I'm not going to rent anyone from New York. Like, you know, have there been any cases like that?
Yeah. Not that I'm aware of. There might be. We haven't had any. And that's, yeah, it wouldn't be protected. Yeah. Although I'm sure someone could, like, you know, you can get creative. They could probably be like, well, why don't you want to rent to me because I'm from Texas? And then I'm sure there are other reasons maybe. You know, it's like people can get creative. Well, where are we? Okay. Oh, there it is.
Thanks, Reed.
Thanks. Okay. So, sex discrimination. Did I go over everything here? Yeah, so examples. Approving a man over a woman on the assumption that men will take better care of the home. Yeah. I mean, yeah. We want fair housing to be fun for all. So approving women over men under the assumption they'll be more quiet. So men, you're in this too. There's room for you here. Denying an expecting mother under the assumption that she'll lose her income source. That does happen. We had a big complaint. It was actually, a woman was denied a mortgage loan because the lender was like, you need to be back at your job because, like, I don't believe that you're going to go back to work.
Oh my God.
And you need to show me like 3 months of pay stubs or whatever. Yeah, so that happens. Repeated unwelcomed advances or comments by staff. That's that harassment, sexual harassment, which is a big thing right now. I think the Department of Justice is really trying to figure out how to get more reports of that because we know it's happening, but people don't report it.
So this is referring to advances or comments by staff of the housing unit to the renter.
Yes.
Or
So
the
like
landlord, or
landlord,
Right.
maybe it's a maintenance guy, maintenance staff, maintenance woman.
Vendors. Is that, or commercial?
people working in the building.
Yeah, vendors. So, and again, denial based on a stereotype about how a person should dress or act or engage in personal relationships.
about unwelcome advances from a tenant?
I mean, I think that would be that like tenant-on-tenant harassment. She was asking about unwelcome advances from other tenants.
I'm talking about from a tenant to a
Right.
landlord.
Oh, from tenant to a landlord. I mean, that's it. Yeah, that's interesting. Probably.
That would be covered by other laws.
Yeah, I think it'd be covered by other laws. It may. I don't know. That's a really good question. I've never gotten that one. Rachel's got it down though. Yeah. So, another bit about sex discrimination that's important is the impact that it has on domestic violence survivors. So, there are policies. I know a lot of housing complexes have policies that, I don't know. Well, I think I get to that on the next slide. So I know a lot of places have policies that are like police activity. If there's any police activity at your unit, maybe it's a 3 strike and you're out, maybe it's 1 strike and you get evicted. Like there's a lot of crime-free ordinances right now that are being like enacted by municipalities, and those can have a disparate impact on women because women are disproportionately survivors of domestic violence. And so that's kind of how it ties into the sex. Like someone could bring a complaint based on sex because of that. Because essentially what's happening is a woman, might be being forced to decide, well, do I want to keep my housing or do I want to call the police for my safety and safety of my family or something? So if a housing provider has a policy like that, maybe revisit that. Because again, with that disparate impact, it's not discriminatory on its face, but it's important to think about the populations that might be affected by rules like that. So rejecting applications because someone, maybe they've got, they're a survivor of domestic violence. Housing provider says, I don't want that on the property. I don't want, that drama or something.
But that's against the law, right?
Yeah, that's against the law.
That passed last year saying that you cannot, survivors
Exactly.
are entitled.
Yep. Mm-hmm. Yeah. Question?
So we actually have an instance where we had a husband and wife, and she had contacted the police on multiple occasions and had a restraining order and all of that, but they were both on the lease. And she asked us to change the locks and remove him from the lease. And at what point, are we allowed to do that? What do we do in that situation? Where she's the victim and she wants him gone as the abuser.
Yeah. The question was if a woman if she's the survivor of the domestic violence and her abuser is on the lease and she requests that he be removed from the lease. I do think that she can like bifurcate the lease. I know Rachel's been doing a lot of reading on this one. Yes. You might want to like check into. Do you have more insight?
There's a protection order.
Yeah.
Mentioned, right? He's not allowed to go back to the house anyways.
But then it's the obligation to still pay the rent, is he then to say,
Yeah, he has an
"I'll pay the
obligation
rent
to
on the
still
lease."
pay the rent for a certain period of time. There's some nuances to that. It's not straightforward, but yeah, you can be removed from the lease.
Okay.
Yeah. I did have a tough one though recently that was I think she was on, it was like with the combined income, she was on like, she had a voucher or something, and if he was gone, she wouldn't qualify to live in the unit. Yeah, and that's tough.
And sometimes by her asking you to remove him from the lease might be because she may be able to apply for some financial help that she might not be able to get if he's still on the lease.
Yeah.
So there's a lot of
it's definitely complicated. It is really complicated.
Yeah.
So, okay.
Yeah. But, we could get you info. Yeah.
It's not an issue. It's not an issue anymore.
Oh, yeah, but just generally.
Generally,
Yeah.
I know what.
Yeah. We can get you that info.
Especially if that person has been arrested by law enforcement.
Yeah. I think we actually go into that in the next slide a bit. Oh, well, yeah, that's like the victim terminating the lease. So, yeah, she can terminate the lease without further obligation, but she does have to provide, I have it in my notes here. Do I?
She has to provide a police report, either a police report or some other kind of documentation saying that she is a victim that was written within the last 60 days, I think it is.
Yeah.
And so
An advocate can help her do that. And I don't think there has to be a police report involved.
yeah, it just has to be some kind of documentation.
Yeah, like an advocate or an advocate,
Yeah.
like us, we're advocates, and we could help someone do
Yeah,
that.
exactly.
Not necessarily with a police report.
Hmm.
Any other questions right now? So again, yeah, under Colorado law, a landlord cannot terminate a lease or rental agreement or impose a penalty on a resident for making a call to police or emergency services in response to domestic violence. So, oh, that was on there. Yeah. Oh, sorry. There we go.
You additionally have the right to terminate.
Right, so the victim could terminate. Survivor, rather.
For the survivor.
Yeah. So right, this is kind of what Rachel was saying. So the tenant can, they can notify the landlord in writing, and provide copies of just one of the following: police or court report, protection order, signed document from someone who's assisted the tenant related to the domestic violence committed. So you all, or a statement or other evidence. That's up to if the housing provider is willing to accept something else, that's great too. So that's all the federal protected classes except for disability, which we will return to. But we'll quickly run through the Colorado protected classes. Looking at the clock. So ancestry is, it's related to someone's line of descent or lineage. That also kind of covers if someone is discriminated against based on their dress or their culture or their language. It's very similar to national origin. Creed is a set of moral or ethical beliefs or the practices or observances associated with those. And so traditional religions or organized religions are covered under creed as well. And they're also covered under religion. But creed also is say I am in a leasing office and I am reading a book on Wicca or something. And the housing provider's even if I'm not Wiccan, it can be a perceived thing. So if the housing provider is perceiving me in a certain way based on my creed, that's covered. I don't know that, political affiliations are not considered creed. We found that out for sure. We had a guy who was responding to emails. Someone would inquire about a unit and he would just say Trump or Hillary. Yeah, and so we were creed? But Civil Rights Division said no, not creed. And I think that's actually written in the statute that specifically political affiliations are not.
Was the question allowed then?
Yeah. Yeah, but he was doing a lot of other stuff that wasn't allowed, so yeah. Yeah, so creed. Oh, I had a fun one where a guy was, sorry, I shouldn't say a fun one. He was calling about marijuana. Now, it wasn't medical. It was just recreational, and he was telling me that was his creed, which It very well might be, but marijuana is still federally illegal, so Fair Housing Act's a federal law. It's kind of, no one's really touched that yet. I'm sure in the future, yeah. So marital status just refers to someone's state of being married, divorced, widowed, single, refusing to list an unmarried partner on the lease, being asked for a cosigner. This usually is women only, but like they'll be asked for a cosigner because they're single. Or, all tenants living together must be related by blood or marriage. Marital status, just like we said earlier. Sexual orientation. So this is a little odd. Obviously, it's your whatever sexual orientation you are, that's protected. Lesbian, gay, bisexual, queer, heterosexual, however you identify. The Colorado statute actually lists that transgender and gender non-conforming folks are protected under sexual orientation, which good. That's good, even though they're not the same thing. Someone's gender identity and their sexual orientation, it's not the same, but we'll take it. We'll take the protection because that's good. So again, kind of similar to sex where, if it's like how a landlord doesn't want to rent to someone based on how they think certain people should act or not act, how they conduct themselves in their personal life. Stating that renting to an applicant would violate a landlord's religious practice. That's the one. We've had some pushback on that in recent weeks. So I don't know. But as it stands, it's still illegal in Colorado. Refusing to renew a lease or put both partners' names on the lease. Yeah, just generally like giving them differential treatment because of their sexual orientation. Don't do it. Questions?
So
Okay.
a landlord that was discriminating on the basis of sex, which is not a federally protected class, could take it up to the federal level in saying that they should not be counted as being discriminatory, correct?
Yeah. Well, sex is protected, but you meant sexual orientation.
Yes, sexual.
Yes, they could do that. I'm sure that there might be something to that effect in the hopper right now. Because I know there's a lot, and this is not fair housing, it's public accommodations, but I know there's a lot of similar cases to the Masterpiece cake shop that are floating around. So, yeah. Potentially bad for fair housing advocates, that Supreme Court decision. Fair housing and disability. So, reasonable accommodations and modifications are like accommodations are changes to rules or policies so that a person with a disability can have equal use of and access to their home. So reasonable modifications are like a structural change to the property, so the grab bars in the bathroom, the ramp, that kind of thing. So the definition of disability under the Fair Housing Act is really broad. Basically, if a person has, they have a condition that substantially limits one or more of their daily life activities, that's considered a disability. It also protects folks like that perception thing again. If a landlord doesn't rent to me because they like think that I have a disability, even if I don't, I'm still protected under disability. Question?
I have a question. Like if somebody has a house they've lived in for years and then becomes disabled and wants to put a ramp or something, can the city actually turn them down saying, no, that's not legal?
No. The city. Is this like a single family home or?
Yeah, well, a single family home, that they've lived in for years, if they need to add on, that would add on to, you know, the FAR of it or something, can they say, no, you can't put that on, you have to move?
I don't think so. Sorry, the question, I need to be repeating my questions. It was, can a person living in a single family home make a modification, you know, if they become disabled, and can the city deny them? Because, what is an FAR?
Floor area ratio.
Okay.
Like the total amount of of a house.
Like
would be
area.
on it, yeah, but that would be added on the outside of the
Yeah,
house.
I don't think so. I don't think so. I mean, we'll get more into modifications, so your question might get answered. But if not, we'll follow up. Was there one over here?
Yeah, I had a quick question for you. So we have to allow reasonable modifications, but the property has to be turned back to the previous state, correct? So they have to pay for their own reasonable accommodations and then has to be returned to the original state, correct?
Yeah, so if well, actually, we're going to get to that. I'm going to pause. So, disability, moving on. Examples of disability. I mean, you know, blind and low vision, deaf and hard of hearing, autism, epilepsy, muscular dystrophy, cancer, HIV positive status is considered. Depression, anxiety, PTSD.
What if it's a short-term disability?
So like if you get injured and you're on crutches.
Yeah.
I think with short-term, with disabilities like that, if it's going to be like, oh, I'm on crutches for, I don't know, 3 weeks and I want you to install an elevator. It's like, well, no. If they're going to be on crutches for a year, I think that's kind of pushing, like, I don't think that would be considered short-term necessarily, because that could be a full lease term. So if they request, you know, some kind of modification or something or accommodation, I think it'd be wise to approve. Drug addiction and alcoholism is considered a disability if they are like actively in recovery. They can't be currently using, because I think that could pose a direct threat to, you know, residents of the property. So, you know, for that, if they're like in a program and they can give you documentation that they're in some sort of rehabilitation program, or, you know, if they're going to the methadone clinic or something like that, that's considered the disability, but not if they're currently using. Questions? Okay. Reasonable accommodations. So these are, again, an exception to a rule or policy so that a person has that equal access. If there is a cost associated with a reasonable accommodation, typically falls on the landlord. So that's like emotional support animal. You know, can't charge pet rent, can't charge upfront fees. Obviously, if the pet destroys the unit, you can take it out of the security deposit. But, you know, that's an example of the housing provider sort of eating that cost, the upfront cost. Painting, you know, creating like a accessible parking space is considered an accommodation, even though it kind of seems like it's a structural thing. Because, you know, if parking is provided, then that's a policy or a service essentially that the housing provider is giving to their tenants, and so they would pay for that spot to be created. Questions? Service and emotional support animals. So they're not pets. They are not subject to pet policies. Housing provider can't make someone with an emotional support animal sign a pet agreement. Obviously, they still have to behave, like they can't be snarling at people and biting children. But, you know, it's not a pet. It's like, just forget that animals are pets. Just think of it as like an oxygen tank. You know, like it's a medical necessity for that person. Question?
Sign an emotional support animal agreement or rules or something along those lines?
No. The question was, can they be made to sign an emotional support animal agreement? The answer is no. They can't be subject to any like agreements prior to, you know, like, okay, an example of when you could maybe do that. and like this might be getting too hypothetical, but like say you approve the support animal, things are going okay, and then it starts like acting up, and it's, you know, maybe snarling at people or like whatever, or that it's not being cleaned up after. You could say, you know, hey, I know this is your emotional support animal, but like you still need to be taking the proper precautions so that it's not threatening to other people, you know, and if it keeps being an issue and it's not being addressed, you could potentially maybe come up with some sort of agreement. You would obviously want to talk with the tenant and say, hey, can we work something out here? But up front, they can't be made to sign anything.
Can you require them to be on a leash?
City ordinance.
That's a city ordinance. All dogs have to be on leashes, so yes.
Or a cat?
Yeah, and I mean, I think that's reasonable. I mean, I don't know. You're thinking?
The only reason I say I don't know is because I see emotional support animals and service animals all the time that aren't on a leash. And I've never seen anyone get ticketed, so it's probably not enforced if it is, but maybe we should look into it.
Here's my roundabout answer for you. To can you require the emotional support animal to be on a leash? If, for some reason, due to the nature of their disability, they cannot use a leash, maybe they have limited mobility with their hands or arms or something, you know, that would be a time where you probably couldn't require that. If it doesn't interfere with their disability or the accommodation and how the dog helps them, you could probably require that.
What about proof of like spay, neuter, vaccinations, things like that are required of all other animals on the property?
We generally, the question was proof of spayed or neutered vaccinations. We generally say yes, just because that's okay, because, you know, if a dog has rabies, that could be seen as a direct threat. So they're in the joint statement on accommodations from HUD and the Department of Justice. They spell out like this direct threat thing that I keep referencing. So you might, if you just Google like reasonable accommodation joint statement, it'll be the first link. It's on HUD's website. And so if an animal if an accommodation would cause a direct threat to other residents, other animals, the property, damaged property, yeah. So I think the vaccination thing, we generally say sure. I mean, if someone wanted to push back, they probably could, but yeah. Question?
We have people that are allergic to pets. So we have people sign leases in a shared living, multiple bedroom apartments, and they bring in their cat or whatever, and
yeah,
they're allergic, so find ourselves in kind of a jam.
Yeah, so the question is shared living spaces and allergies, you know, other tenants having allergies to pets. So that's always a bit of a gray area. There is a roommate exemption. So if someone is like looking for a roommate for the third bedroom or something, and they're really allergic, I mean, I would hope that the person discloses that they have the support animal beforehand.
That's not a law though, and it doesn't seem to happen much.
Right. I mean, it's not a law. I would hope, you know, as a roommate, I would say to a potential roommate, like, hey, I have this animal. But the roommate exemption, they could say no. They could turn that person away. They could say the roommate could, because again, it's that shared living space. But I do get questions a lot about, like, oh, I keep this unit pet animal free, so that if someone with a severe pet allergy were to move in, I could put them in that unit, you know, because even if there's animals in the unit, like even if it's cleaned, you can still like smell them sometimes after. And that, we generally advise against that, just because it's like, it's showing preferential treatment for a hypothetical resident when there might be someone with an actual housing need. Like, I'm interested in a unit, and the only unit available is this pet-free unit. And so you deny the person based on that when there's no actual person living in that unit or needing that unit right now. So that's kind of similar to what you're saying, and we advise against that.
It sounds like you wouldn't like us to set up a few units for pets, so that if we did have support animals show up unannounced, we could have a unit?
I don't know. I mean, that could be steering. Like, I would advise against putting any kind of like, any policies or rules about, you know, emotional support animals or pet-free units or whatever, just generally. Was there a question over here? Thought I saw it. You.
So we actually have quite a few owners that come here and live here seasonally. So not even necessarily a hypothetical tenant. We actually have owners that'll say, no, I don't want any pets in here because I do have an allergy and I can't live here for Christmas, you know, the holidays or something. Can they say, no pets?
So the question was, can an owner who lives seasonally in Aspen, lucky duck, say I don't want to rent, you know, on the off season I don't want to rent my unit out to folks with animals. If they're exempt, if it's Mrs. Murphy, then yeah. Anyone else? Okay. So again, this is causes a lot of confusion, but so the Americans with Disabilities Act, which applies to public accommodations, not housing, does have like tighter restrictions on service animals. They have to be trained. They can be like a dog or a pony or something. I think those are the two, right? Like miniature pony and dog.
I just can't figure out the snake one. How do you have an emotional support snake?
Yeah. Right. But under the Fair Housing Act, there is no distinction between emotional support and service animals. They're all considered the same. We kind of refer to them as assistance animals just to kind of eliminate that distinction. So there's technically like no like certification that is required or that the tenant has to have. But going off of your statement, I had one. I was proven wrong here. I had sweetest family ever. They had emotional support chickens. They had 10. And they lived in an HOA, so they owned their home. But obviously HOAs they like their rules. And, you know, the HOA was pushing back and saying, oh, we don't allow poultry. How is this providing emotional support? And I mean, yeah, we all have those thoughts. She called me and I was like, okay, all right, 10, all right. But it's not my job, you know, I was gonna help her out. So I went, visited her family, saw the chickens. Turns out she had a daughter with Down's syndrome, and the chickens, the daughter was taking care of the chickens. She would care for them, you know, harvest the eggs, harvest the eggs, collect. She would collect the eggs, you know, yeah, she would like clean up after them, like care in the coop, everything. It was an activity she could do with her mom. It's like bringing a tear to my eye right now. You know, it gave her daughter purpose and it helped her with like critical thinking and problem solving. And so that's legitimate. And, you know, sometimes they are very unique and odd ways that these animals help out. And on its face, it sounds kind of ridiculous sometimes, but it isn't always. So as long as they can provide that doctor's note that states, like, this is why this person needs this animal. However, if it's like my emotional support boa constrictor, I don't know, rattlesnake, I mean, that's direct threat. You know, you can't be having a rattlesnake in an apartment building. Or if they want an elephant, it's like, well, that's an administrative burden. You can't have an elephant in a studio apartment, like, or I don't have the grounds to house your elephant. If it is truly like something that the housing provider just can't accommodate. But to have that dialogue, you know, that's what we always push, is like, just have the dialogue. No is never the right answer. It's never just no. It's maybe no, but what else can we do to accommodate you? Is there something else that you need? You know. Question?
So we've seen a lot of this lately here, especially with seasonal residents coming in and out, and they will one day not have any documentation, by the next they'll have it, but it won't be from a doctor. They can go online, pay a certain amount, get a note. How do we determine these things to be legitimate or not?
Yeah.
And how, I mean, there's obviously that's a long question that we have to figure
Yeah.
out, but are they gonna start regulating, hey, this is a site that you can see, these are the doctors' names that obviously never prescribed it in person, but you can just go online and get a note. Is there something there that you can tell us is?
Sure. That is definitely a hot topic right now. I think there will be some pushback in the housing world in the future, in the near future, on exactly what you're describing. The question was, if a lot of folks are like, getting the animal, don't have the note, get the note from an online source, they pay $50, it's an emotional support animal. In the fair housing world, the argument against, that person's working for profit, they're not your doctor. Any doctor is working for profit, it's their job, right? So it's like, who's to say who is, a lot of people feel that it's not the housing provider's right to make that call. It's between the tenant and the doctor, and it's not for the housing provider to say that's an illegitimate source. Technically, in the joint statement, it says a reliable third party. It could be like your mom, someone who knows you and is associated with your disability. We don't generally advise that people do that because they get too much pushback. We always say, just get the doctor's note. It's the easiest way. But technically, someone could say, this is a reliable source. They know me. They've known me since I was a kid. I need this cat. I'm going to file a complaint. But
so to play it safe, we should be accepting everything.
Well,
basically, right? I mean, we don't want to risk violating this. So, where do we draw the line about what's a legitimate source?
Yeah. The question was, where should a housing provider draw the line on what's legitimate? I can't answer that for you. That's for you all. That one's for y'all. What's up?
I see some HOAs, their insurance prohibits certain breeds of dogs, like Akitas, Rottweilers.
Yeah.
Pit bulls. Is that considered discriminatory?
The question was breed bans or breed restrictions and size restrictions. Yes, that is considered discriminatory. It's in that joint statement.
It's only discriminatory if they're a service animal.
Right. If it's a pet, yes. But if if you have no pit bulls or whatever, and someone has an emotional support pit bull, even in Denver, we have the pit bull ban, they can still have that. And that's explicitly written out. It's not like an interpretation of the law. That's in that joint statement. So very handy document for everyone.
Well, I noticed more in the insurance companies that insure the HOAs.
Yeah, that too. The question was insurance companies that insure the HOA or the housing provider, if they have breed restrictions, that's also discriminatory. So the insurance company would be liable there. Yeah. Question?
We, once again, have a lot of pets that come through, and some are not taken care of in the way they're supposed to. They don't pick up after them. Obviously, there's testings and ways to figure out whose dog they didn't pick up after.
Yeah.
What and how much documentation do we need in order to legitimately revoke their lease after they've repeatedly gone against, the regulations? So.
Yeah. The question was, if someone isn't taking proper care of the animal or not cleaning up after it, in common areas or something, what rights does the housing provider have to sort of take action there and maybe terminate a lease or something? They still have to follow basic rules. Basic decency. Pick up after your dog. Don't be damaging communal property. And that's probably in the lease too. If you cause damage to the property. So just because it's an emotional support dog doesn't mean that it can just run roughshod all over the place. And that's just fine. So I would say in that situation, say you have a 3 strikes clause in your lease. If you make the tenant aware, you say, hey, we know that this is your animal, as it stipulates in the lease, you need to be cleaning up after it. And they don't clean up after it. You give them another notice, they still don't clean up after it. As long as you're following what's in your own lease like that, that's fine. Because, yeah, I mean, they can't be damaging your property.
So we can't have them sign pet policies, but we can put it in the lease?
Well, usually a lease will have like a clause about damage anyway. It might not be specifically addressing like animals, but if the tenant, I mean, the animal is associated with the tenant's responsible for the animal. So if that's in the lease, and that has nothing to do with their disability, it has nothing to do with their animal, but they're causing damage to the property or something that they own is, you know, so yeah, like you can't have them sign that pet agreement, but if they're violating the lease, that's a lease violation, right? Yeah.
If we don't have them sign a pet agreement, but we have a pet, say, policy that we hand out, can we do that for all pets? All animals, animal policy.
Yeah, I mean, that wouldn't, sorry, the question was, if there's like a pet policy that they just hand out. So you're saying like maybe they don't sign it, but you just give it to everyone, right? Again, you know, it's not a pet. It's an emotional support animal or assistance animal. So, I mean, I guess I would advise against that, because if there's already a damage bit in your lease, that's just going to cover everything. Like, you don't need them to have that pet policy necessarily, because if they're causing damage, that's that lease violation again, you know?
Or if it's an HOA, if you have an enforcement policy, you can have any policies for an HOA. We don't have an HOA. So I'm just thinking, I can just see pushback on that, like, nobody ever told me I have to clean up after my dog. Or, you know, I mean,
yeah.
Without having something that
No, those
says
are
that.
basic things. They do have to follow basic rules. They have to keep them on a leash, they have to clean up after them. I mean, they still can't be aggressive. There's basic rules they still have to follow.
That's a city rule.
That's a city,
Yeah.
City rules.
Yeah. I know, it's a messy zone.
Lease could have terms about damage, nuisance, and animal waste sort of lumped together, couldn't it?
Probably. The question was, could a lease have damage, nuisance, animal waste, like lumped together in a clause? Sure. I don't know. Wrap it up. Okay. I feel a little odd, like advising landlords like how to phrase that kind of stuff. But no, I know. But I mean, yeah, because again, it's that damage. You know, it's damage. They still have to follow the lease.
It would be that hard to write that in a non-discriminatory way.
Exactly. Yeah. Animal waste. Okay. We're short on time. So handicap parking, I think most people get that. That's, you know, if someone needs a reserved accessible space close to their unit, the landlord should work to provide that. Question?
It's a really odd question, and I'm sorry to even have to ask it, but we actually have a complex where there is nobody that is handicapped currently living there. And we have a lot of residents that decide to take the handicapped parking spot, and I told them not to, and they've asked, well, nobody lives here, why do we not have to park here?
Yeah.
It seems like a silly question,
Right.
but what if someone breaks it?
Yeah, I mean.
It seems like a silly question, but it's actually come up more than once.
Right. So the question was not able-bodied folks just parking in accessible spaces because there isn't someone who needs that space who's actually using it. I mean, this is probably a lease violation, right? I mean, you can't. And it's a city. Yeah.
Once
And-
they get a ticket for it.
Yeah, or like tow. Call the tow.
They'll learn then.
Yeah.
The city laws don't apply to private property.
Right. I mean, they do if it's like future resident parking, like outside the office.
The county sheriff can enforce that on private property.
Oh, county
For sure.
Yeah.
In fact, what we've seen enforced by the county sheriff here is when we have a ADA type A unit that is an owned condominium, and it's a non-disabled person who happens to own an ADA unit,
Yeah.
the assigned parking space is often a handicapped parking space.
Right.
The county sheriff will cite the person who owns the unit who's not disabled for parking in their own parking space if it is signed as handicap parking. So what we've come to learn is that we're better off assigning a dimensionally compliant space to a type A ADA unit and not marking it as a handicap parking space because it is assigned.
Yeah.
So it gets a little murky.
It definitely does a lot, yeah. And that's a great solution, I think. Because if they moved out and someone moved in who needed it marked, you'd just mark it, right?
It's still a sign, so it
Yeah.
doesn't even need to be marked.
Right, so, I mean, yeah, that sounds like a good solution. Wait lists. If there's a wait list for parking, if someone requests an accommodation for an accessible space, they can and should be given priority on the wait list. Because, it's inconvenient for me to walk farther to my unit from my car, but it's not like hindering my ability to get in and out of my house. So, modifications, these are quick and easy. They need to be approved, but you don't have to pay for them unless you receive federal funding. So, yeah, if someone requests like a ramp or whatever, grab bars. Oh, your question was returning it to its former glory. So if it's the interior of the unit, you can ask that. You can say once you move out, it needs to be returned to how it was. If it's the exterior, if it's in a common area like the pool or a ramp to the office or whatever, that potentially benefits the community as a whole. So they would not be responsible for returning that. This is just federal funding. Obviously, if you get federal funding, you have to pay for those modifications. Examples, we kind of went through those. Design and construction. Any building built after March of 1991 has to have certain accessibility requirements met. So, I am happy to point people out. If I have all your emails, I could just do like a mass email with questions answered. And I can give you access to that like design and construction handbook. And there's a really nifty website that really establishes things clearly, so I can do that. I think that's it. Yeah, we just got examples. We're done.
Thank you.
You're welcome.
Thank you.
Yes. So please fill out the evals. Thank you.